Hey folks, Don DeRosa here. Today I want to try something a little bit new. I'm going to start a new project where I take random questions throughout the internet and I answer them and give you my opinion of the question. So please, if you like this, let me know in the comments below. Give me a like, a thumbs up, and subscribe if you enjoy this. So today's question came from a guy by the name of Dwayne Williams. Now I don't know these people, but I'm taking random questions which I think everybody may want the answer to, and I'm just going to give you my opinion of them. This question came from, again, Dwayne Williams in the Facebook post on Jonathan Rexford's Facebook group called Subject to Real Estate Investing. Okay, so if you want some good information, be part of a group, go check out Jonathan's Facebook page. And again, it's called Subject to Real Estate Investing. And Jonathan, I've known Jonathan for 20-some years. He's a great guy. So anyways, the question is this. I have a property I acquired subject to, and I just found out the seller that I bought it from passed away a few months ago. How will this affect his current mortgage? And is there anything I need to prepare for? Let me turn this off. Well, that's a great question, and one that, as I say, depends. In real estate, a lot of it depends, and it depends on these things. Number one, the first thing you want to consider is, how was this closed? Now, he said he bought it several months ago. Well, that would mean, okay, that you have to ask yourself, because there's a lot of ways to buy property subject to, and one is considered an arm's length transaction. So you have to ask yourself, how did you buy this and when did you buy this? So was the guy of sound mind and body when he sold it to you? And did you use what we call an arm's length or third party transaction? What I mean by arm's length is, did you close it through an attorney or title company? And did you go through a normal traditional type closing, even though you bought it subject to? Because if you do it that way, it is truly an arm's length transaction. And when somebody, or if somebody were to challenge the probate, then you would have a better chance of it upholding the transfer to you, because it is a third party transaction. Okay. Now, however, if for some reason that you do the the old style type closings, where we used to call them Waffle House closings or tabletop closings, if you will, where you just go and you sign all the documents, get it notarized at a local notary, and then you file the documents, file the deed, file all that stuff yourself, there is a good argument there that the family members can come challenge that, because it is not considered an arm's length transaction, and therefore the judge could come back and reverse the transaction if there was some reason that the paperwork wasn't done properly or whatever the case is. So rule number one, first thing I always recommend is make sure you close it as what we call an arm's length transaction. It's not that much more money to close it, and then you have the protection of so now you have your attorney or title company that can go to bat for you if something like that happens. So let's take a look at the second, or maybe even the first part of the question. He says, I bought it and the person passed away a few months ago. How will this affect the current mortgage? It won't, or shouldn't. Well, what will happen is the property, the heirs, will have to go through probate. Depending on whether he had a will or if he didn't have a will. If he had a will, it should all be spelled out who gets what, and it should be fairly simple, and there will be an administrator. Now, if the loan is still in his name, which indicates so with a subject to transaction, that is just the loan, okay? You will, however, you should, however, get a power of attorney. If you haven't gotten one from him before he deceased at closing, you should have. But let's just say he died, and that renders that power of attorney a moot point. You will need to go back to the administrator if it wasn't probated, or the executor or executrix of the estate, and get an additional power of attorney. Hopefully they'll give it to you. So that's going to be one of the challenges. So it's always better to play nice and do that. So will it affect the mortgage? As my experience is no, because as long as you're making the payments, they won't matter. But you will need, however, that power of attorney to be able to service that loan down the road. Now, some banks won't recognize that power of attorney once the death certificate is turned in, unless your power of attorney basically says it's good forever and ever and ever, even if they've been deceased, because you're going to want to service that loan. And what I mean by servicing the loan is, if the escrow goes up, you need to change tax, you need to change insurance, you need to be able to contact the mortgage company to see if anything changes. Because if you don't have that document or something that will allow you to talk to the bank or the lender, under the Privacy Act, even though they're deceased, under the Privacy Act, they may not talk with you. So, for example, if your payment is $1,000 a month, principal, interest, taxes, and insurance, and your escrow goes up by $200, and now it's $1,200, and you keep sending in $1,000, sooner or later that property is going to go into foreclosure, because what happens is that $1,000 goes in, and because you didn't pay the full $1,200, it goes into what's called an unallocated fund, and it just sits there. Well, that loan goes 30 days behind because you didn't send in a full payment, and then next month when you send that in, you now have $2,000 in that account. So what they'll do is they'll take out the late fees first, then they'll pay the $1,200, and now you'll still have X number of dollars in an unallocated fund. So before long, you keep sending that money in, and you keep going 30 days late until you get to the point where you're a little bit behind, and eventually it will get to a point where they may foreclose. So that's why it's important for you to have that document, that power of attorney. And generally an authorization won't be able to do it, because you can maybe talk to them about it, but you cannot change anything. You can't send in any adjustments to escrow, change any addresses or anything like that. So you're going to make sure that all that stuff is done beforehand when you buy it initially. Make sure you have a power of attorney, make sure you get all the documents signed so that you can service that. So the next question is, how will it affect my current mortgage? And it really shouldn't. It may, but it really shouldn't, as long as your payments are current. And is there anything I need to prepare for? As I said a little bit before that, is the thing that you should prepare for is find out who the administrator or the executor or executrix is, communicate with them, and the best thing to do is to get them to give you a power of attorney, a new fresh power of attorney, so that you can service that loan. Now the challenge is going to come in if there's a combative situation where they're just, they refuse. Then you may have an issue there, and you may have to get your attorney involved, which is an unpleasant situation. But it very well could happen depending on the heirs and whether or not there's animosity there. So my suggestion is get the necessary paperwork drawn up, do a traditional arm's length closing, and then just keep the payments current. So I hope, if you have any questions, please put them down in the comments below. If you like this and you'd like to see more of this, give me a thumbs up. That goes a long way. And if you would like me to send you stuff every week, hit the subscribe button and we'll send you another one out every week. I hope you enjoyed it. This is Don DeRosa. Thank you very much. Happy investing.